Hi, this is Joe Miller, Virginia Workers' Compensation Attorney with the Work Injury Center at Joe Miller Law. Welcome to our Critical Info CD for injured workers. First of all, I want to congratulate you for having the presence of mind to order my book. It shows that you're an intelligent person who wants to make smart decisions about your life. Because believe me, in particular those of you who have suffered a very severe injury involving surgery or multiple surgeries, right about now, your life is turned upside down. Besides the fact that you're hurt so badly every day, you probably feel a little like a criminal. You've been made to feel that somehow the fact that you got hurt on the job is your fault. You're the one who's in horrific pain, suddenly able to function. You're worried because your future seems uncertain now. You feel like the rug's just been pulled out from under you. And on top of that, you're treated like this. It's intolerable and it's wrong. What's more, even if you're getting your comp checks, they're a third or less than your usual paycheck, so you've had to make some serious adjustments in your budget as well. So more likely than not, right about now, you're pretty angry. In fact, you may be mad as hell. Well, I'm here to tell you that you're not alone. You're not being personally singled out. Everyone typically gets treated poorly when they get hurt on the job. Why? Because the whole show is being run not by your employer, but by the workers' compensation insurance company and the insurance adjuster. And the insurance company is not in the business of handing out money. They're in the business of spending as little money as possible on each claim. And believe me when I tell you, even if the adjuster has been nice up until now, even if they've paid for everything, no problem, there will come a time when that's going to end. And that is what this CD is really all about. It's about setting things up so that when the time comes for the insurance company to drop the hammer on you, which I guarantee you will eventually happen if you don't take certain steps, your rights will be solidly protected. Okay? Why is this so important? Well, as we stress over and over again, if you watch some of my videos online at joemillerinjurylaw.com and in my book, as I stress over and over again, the employer and insurance company are not obligated to pay you one single penny or pay for any medical treatment unless they are ordered to do so by the Workers' Compensation Commission. Well, I need to say that again because it is so important to remember. The employer and insurance company are not obligated to pay you one single penny or pay for any medical treatment unless they are ordered to do so by the Workers' Compensation Commission in Virginia. But they might do so voluntarily for a while. They may want you to think they're amazing. They want to convince you that you're all taken care of. But that's just to lull you to sleep. They want you to be off guard so that you're completely shocked when your benefits are completely cut off. Now, one of the things we hear all the time is this. Well, I'm pretty sure my employer filed my claim with the commission for me. Everything's okay. Well, I'm here to tell you there is no such thing as that. Only you or your attorney can file your claim for benefits for you. If the insurance company is claiming that they filed your claim for you, I'm here to tell you that they are lying to you. Now, what they may have filed is a notification of injury, which has nothing to do with what you had to do, what you have to do, and which does not protect your claim in any way. That's just something that they have to file with the commission to tell them that there's been a work accident. That's it. So, who needs to worry about all this the most? The ones who need to worry about this the most are the folks I'm going to mention in a moment who I fall into something that I call category number 2. Okay? So basically, what we tend to see is that workers' comp claims fall into 2 very broad categories, which I'm going to describe right now. So let's first talk about category 1. Right? These are those folks, those of you who are listening to this, who are injured, but you're not injured too severely. Perhaps you suffered a sprain or strained your ankle, maybe your wrist, your shoulder, or other body part. Maybe you might have a cut, you might have a few scrapes, some slight burns. It hurts, obviously, but you may be young. No surgery or any major treatment is indicated. Neither you or your doctor anticipate any significant lost time from work or future treatment, if any, or anything. If anything, maybe a week or 2, and then, you're back to full duty. So for you, although it's important to protect your rights, you're not in as critical a situation as those in Category 2. So let's describe who's in Category 2. This refers to those of you who are severely, even catastrophically injured, and you required a hospital stay after you got hurt. Okay. Most likely, the doctor who is treating you now is the one who performed surgery on you in the hospital. You likely had surgery to one or more body parts as a result of your work injury, and you may have had multiple fractures, some severe, or even an amputation or more than one amputation. You might be older, approaching the age 60. And both you and your doctor are really concerned right now that your injury may prevent you from returning to work, or at least from returning to the job you were hurt on. So you're expected to remain completely out of work due to your injuries for the foreseeable future. Now, I realize that not everybody fits neatly into each category, so you may not be sure if you fit into category 1 or 2. But if you're not sure, I'd suggest that you assume that you're in category 2 and proceed as we recommend for those folks. But, for those of you who know that you clearly fit into category 1, the less severe injuries that I described, with really very little or no time lost from work, with very few exceptions, I have really good news for you, and that is this. You're really not going to need an attorney, okay? More likely than not, you're not going to need one. And that's because I can basically show you how to get your claim up and running. And pretty much everything you need is going to be on this CD and in the package that I provided for you. I've included in this package here 6 sample documents with sticky numbers on them, and along with copies and blank copies, and this is for everyone's reference. And I'm going to explain to you basically what to do with those documents in just a second. In fact, I've included a ready reference card to go ahead and walk you through those steps of filing and pursuing your claim. But let me say this before I do that. Those of you in category number 2, the more severely injured folks, I would under no circumstances recommend that you proceed without an attorney knowledgeable about Virginia workers' compensation. Why? Because, if you're talking about an extended period of time with you being out of work, it is absolutely essential that we take steps to protect your benefits and protect them right now. If not, you can lose them at any time. Well, how's that the case? Well, this connects back to the principle that we talked about just a moment ago. And that is, again, that the employer and insurance company are not obligated to pay you one single penny or pay for any medical treatment unless they are ordered to do so by the Workers' Compensation Commission. What would you do if a year from now, still unable to work, your benefits were suddenly cut off? What if they were cut off tomorrow? How would you support yourself and your family? In addition, those of you in category 2 may have also suffered from multiple injuries, and it's important that an attorney with expertise looks over your records, your medical records, make sure that everything is filed appropriately with the commission and included in any claim for benefits or award agreements that are sent to you. This could prove crucial at a later time. Also, if you're in category 2, your medical records are going to be extensive and very large, and voluminous. You can rely on the expertise of a knowledgeable attorney and their staff to sift through those records and file with the commission only what is most relevant to your claim. The commission doesn't take kindly to large filings and piles of records. Okay? In addition, if you're suffering from some severe incapacities due to pain, the pain medication that you're on, you're not able to focus so good, maybe you're weak, you're laying in bed, you can rest assured that the insurance company is going to be taking full advantage of you by sweet-talking your doctors and taking steps to diminish the value of your claim, along with all the rest of the lovely things that I warn about in the 10 Traps of Lies and Lies book, which I've included in this package, which I strongly encourage you to read. But for now, I promised the folks in the first category that I'd help them get started, so here it goes. Now, the documents I've enclosed for the, again, category 1 folks, they're as follows. You'll see document number 1. Okay, that's a claim for benefits. And that's the first thing you're going to need to file, claim for benefits. Document number 2 is a sample 20-day order. Document number 3 is a sample response from the employer and insurance company to your claim for benefits. Document number 4 is an award agreement. Document number 5 is a sample of an award order that comes from the commission. And document number 6 is a sample of a notice of hearing, what that looks like. So category 1, folks, let's go through it now. So step 1 is that you have not yet done so. If you have not yet done so, you should obtain all the medical records from your treating doctors for this injury, for your work injuries. This is not just the stuff they give you when you leave their office, okay? These are the actual office notes that are dictated by the doctor in the back of his office. You need to request those from your doctor and ask that he or she provide those for you. Most importantly, okay, if you've been held out of work, you should be getting every time you leave the doctor's office. And by the way, this applies to everybody. This is extremely important. If you're being held out of work or you're under work restrictions, you need to obtain from any doctor's notes holding you out of work or providing you with restrictions from the doctor. You should have a copy of each of those work excuses every time you leave the doctor's office. Now, after you've done that, you've gotten the doctor's records and you've gotten the work notes. Step 2, okay, is to go ahead and fill out and file that document. First you're going to fill it out, okay, and then you're going to file it. Let's go, but step 2 is really just to fill it out first, okay? So that claim for benefits form that you've got there, you're going to put, the information at the top for you and the employer. You're going to put the correct body parts that are hurt there. As you've seen on the form, you're going to put your average weekly wage, your gross average weekly wage, not after taxes, but before taxes. You're going to put the dates from which you claim you need to be paid, dates you've been out of work, and the part B there. And if it's still going on, you want to put the second part, where it says, first you're going to have the first date, and then in the second part you can put ongoing. If you're still out, if you're not, you're going to put the date you went back. And make sure you ask there's a place there to check for medical benefits as well. Okay. Now, step 3 is to go ahead and file that document with the commission, along with the relevant doctor's records that you got back in step 1. Okay. And of course the work notes as well. Make sure you retain copies of everything. Never file anything with anybody unless you have, or send anything to anybody unless you retain copies. Okay. Very important rule. Also, please know this, and this goes for everybody. You have only up to 2 years from the date of the accident to file this claim for benefits, unless you were under an award order. Okay, from that, and if you were under an award order, then you have 2 years from the last date you were paid benefits, paid workers' compensation check benefits. After that, it's over. It's finished. If you haven't filed that thing, you're done. Now, if you're not sure whether you're under an award or not, I would go ahead and assume that you're not, and make sure you file that claim for benefits with the records within 2 years of the accident. And if you can't do that, then you may be out of luck. Okay. Now, shortly after filing this thing, you're going to get something from the commission that looks like document number 2, and that's called a 20-day order. Okay. What all that thing is something that the commission sends to the employer and the insurance company to ask them to respond to your claim for benefits within 20 days. Okay, that's why it's called a 20-day order. And okay, that's all that is. Next is document number 3. That's called a sample response that's their defense response. Their employer and insurance company are going to respond to your claim for benefits. And they're going to either say, you see the places where they can put this on there, they're either going to say that yes, they're agreeing to your benefits, or that no, we're not agreeing, and they usually say maybe one sentence as to why they're not agreeing. Sometimes they do, sometimes they don't. And that we're not going to agree to anything, and you're going to have to go to a hearing if you want to get your benefits. Okay. Document number 4 is a sample of what an award agreement looks like. That's if they agree to benefits. And if they agree you're entitled to benefits, you're going to get something called an award agreement. And when you get it, okay, if it looks good, step 4, and that means that they put the right body parts, they put your proper average weekly wage, etc. Step 4 is that you should go ahead and sign it and send it back to the adjuster. Don't hang on to it. I mean, you want to keep a copy, a signed copy, but get it back to the adjuster. Also, I would send a copy to the commission as well, so that they know that you've done your part by returning the agreement to the adjuster. Let them know that you've done your thing. Okay? You're not just sitting on that award agreement. Now, after that, step 5 is you need to stay on top of that adjuster and, to go ahead and do their part and, sign and send that award agreement to the commission. They have to sign it too. Okay? And once that happens, the commission is going to go ahead after a week or two and convert that into an award order. Now, I cannot stress this enough, and I say this in many places on my videos at joemillerinjurylaw.com. An award agreement, that thing they sent to you to sign, is not the same thing as an award order. I have had many clients come to us over the years, well, I've had the thing that I signed, I'm covered. No. Many times what will happen is you'll send that award agreement in, and they'll just sit on it. and there will be no order until, well, there'll be no order, and then you'll be cut off. Okay, so you need the commission to issue an award order based on that agreement, or you have nothing. Nothing. So once the award agreement is filed with the commission and the adjuster sends it in, and files it with the commission, and it's signed by both parties, commission will shortly thereafter enter an award order. And we've included a sample of what that looks like, and that's document number 5. Okay, so step 6 is to go ahead and really make sure that you've kept your doctor's notes up to date even after that thing is filed, in particular if he's held you out of work. Okay, and once that award order is entered and 30 days have passed, that award is considered final, and that's your golden ticket for benefits, and you basically completed the process to protect your claim. As we're going to explain later, that's not to say other bad things can't happen later, but you protected your claim. All right. Now, if you ever get a permanency rating, and again, that is something that you can, if you don't know what that is, I invite you to go online to our, I have videos about that on joemillerinjurylaw.com on what that means, what permanency ratings are all about. But if you think you're going to get a permanency rating, or you've got a rating on one of your body parts, usually it's a foot or a leg or an arm, you're going to want to file another claim for benefits and say basically the same thing. And at the bottom, you're going to indicate what body part you're claiming permanency rating benefits on. Okay, permanent partial impairment rating is the technical term. Okay, and you have 3 years, not 2 years for this one, it's 3 years from the date of the accident to claim a permanency rating on a body part. And even if you don't have a rating yet, if you anticipate a doctor's going to give you one, you should still file within 3 years as a protective measure. Just say, anticipate rating, TBI, to be determined, TBD or something like that. Okay, and then once you get the rating, you'll be able to claim it. If you don't file within 3 years, you can't claim it. Okay. Again, I would look online. If you want to know what a rating's all about, please look online in my video in relation to that. We've also included a sample of what happens if you're in an unfortunate situation where the employer doesn't agree that you're entitled to benefits, and that's called a notice of hearing. That's document number 6. Okay. Now, actually, first you'll get something called saying that the claim has been referred to the docket, and after that you're going to get this notice of hearing, document number 6. And on that, it's going to tell you the date, time, and place where the hearing is going to be, as well as the deputy commissioner who's going to be presiding over the hearing. So, briefly, what's involved in a hearing? It's a little too much to get into on the CD here, but essentially, the hearing will take place in the commission location nearest where your work injury was. You're going to need to have all your medical records and work excuses together and perfectly organized the way the commission likes them. Okay? Each doctor's visit, it has to be separated, and you need to have an index to make it easy for the deputy commissioner to find everything. It needs to be in order also, oldest to newest. And if you have any witnesses, unless you know for a fact they're going to appear with you, either they're your good friends, you're tight with them or whatever, you're going to need to subpoena them through the commission to appear at the hearing. And also, if one of the issues is whether your injury was caused by the accident, you're going to need an opinion letter from your treating doctor, okay, saying that it was caused by the accident. So Category 1, folks, that's basically what you need to do in order to get your benefits going. So I want to return now to the Category 2, folks, for a couple of minutes. Now, Category 2, folks, those of you who were hurt very severely. I'm talking to those of you, now, you don't know if you're going to be able to go back to work. You don't, those of you who are laid up, you've had surgery, or you're expecting to have surgery. If you're listening to everything I had said to the Category 1 folks, one thing should have become crystal clear to you. All right? You are in no condition to do any of these things at this point. And what's more, you have way too much to lose. You're hurting. You're laid up. You're disabled. What you need is a team of folks you can count on to take care of getting your medical records, communicating with the commission, communicating with the insurance company, filing all the appropriate forms with the commission in a way that will protect your rights for the foreseeable future. You want a team to handle all that for you so you can do your one and only job, which is right now to heal and get better. That's what your job is right now. And so to those of you who fall into Category 2 who are listening to this, please, you really should not, under any circumstances, attempt to do all this on your own. I invite you to call us And if we can make you part of our family here at the Work Injury Center, we will do that, because this is what we do. We educate, we inform, and we practice strong justice for the clients that we accept into our family. We'd ask you to please consider it. Your income, your career, your livelihood is simply too important not to do this, not to think about it strongly. So, in connection with that, I'll tell you a little story, because I think it's important to stress this point. Not long ago, this guy, Jim Smith, and it's not his real name, I'm just using it to protect his identity, he came into our office. He says he had a workers' comp claim, and he'd been hurt pretty bad about a year before. He even showed us the award agreements that were sent to him by the adjuster 10 months ago, okay? And he says, I'm a pretty smart guy, and I knew better than to sign that thing they sent me, okay? And by the time Jim got to us, he had just had his benefits cut off. He didn't understand why. He was still under restrictions from his doctor, and his job couldn't accommodate his light duty. Well, so much for Mr. Smart Guy. Had he consulted with us 10 months before, not waiting till a year after the accident, we would have simply told him we'd be happy to look over the award agreement. We would have made sure that he signed it, as we talked about just a moment ago, got it to the adjuster, and now he'd be under an open award. He'd be under an order. He'd still be getting his benefits, and we'd also have a very firm basis upon which we could work on getting him a settlement. But, of course, he thought he was smarter than that. Needless to say, in that particular circumstance, for a variety of reasons, not just that, we declined to represent him. Okay? We urge you strongly, don't let that happen to you, what happened to Mr. Smith, okay? Now, you may be thinking, I'd love to hire a lawyer, but, I just can't afford one. So, listen, we have some great news for you. To hire our firm and our team, you don't have to shell out a dime, okay? Our fees almost entirely come out of any settlement we may eventually obtain for you. Now, I will say that if we get you under an open award, all right, the commission will award me a small fee or a few $100s to come out of your ongoing checks. Usually the carrier deducts, $25 a week, maybe $50 a week, whatever is easier for you, until it's paid in full. And of course, if things tend to go on for a while, say more than 6 months or so, we're having to engage in a lot of work, which we totally expect, this is what we do, we typically will apply the commission for some additional fees, again, the same kind of thing, for the actual amount of time we've spent on your case, no more, no less. Again, it's the same sort of thing, usually a few $100s to cover ongoing expenses. I do have to operate a law firm and pay my staff. But our goal for you, the number one goal, which we benefit from this the most, is to get your case in a posture that offers you the best possible chance of obtaining a significant settlement, and by that I mean at least 6 figures, so that you can move on with the rest of your life and not worry about being financially strapped. Now, out of any settlement, the commission typically approves 20% of your gross recovery as an attorney's fee for our firm. And while every case is different and no lawyer can ethically say they can guarantee you anything, I invite you to look online at joemillerinjurylaw.com for our string of successes over the years. You'll see that we've done it again and again for our clients, especially our workers' comp clients, our injury clients, and what we continue to keep doing day in and day out. So before I close out this CD, I wanted to mention one more thing. In actuality, I got to mention that there's really a third category of folks, not just 1 and 2, really a subcategory of 2, or 2B, if you will. And that's a category is made up of these folks who may have been listening to this CD the whole time and thinking, well, this doesn't apply to me. It doesn't apply to me because I've already done what he's talking about. I'm talking about those of you who, for whatever reason, there's probably not going to be too many of you, but there's going to be some of you who have managed to get yourself under an open award. And to you, I say, congratulations. Either you worked hard to figure out how to protect your rights by studying up. Maybe you studied my website or another lawyer's website, so you really delved into the commission website. You can eventually maybe figure it out if you read it carefully enough. Or you just looked into the rare insurance adjuster who was willing to help you out. It does occasionally happen. So you're under an open award, an award order, and therefore you're home free, right? Well, the answer, we're sorry to tell you, is a big, gigantic no. No way, no how. You are not home free by any stretch of the imagination. I'd again refer you to my book, where I discuss the numerous traps whereby the workers' comp insurance company can still take away your benefits. All they have to do is file a simple paper called an application for hearing. and from that day forward, your benefits will be cut off. Now, how do you keep that from happening? Well, to be truthful, there are some circumstances where you can't keep that from happening. For instance, if your doctor releases you to full duty, you're going to lose your ongoing weekly comp or temporary total disability benefits, although your medical benefits will remain intact. Also, if you're released to light duty and your employer decides to accommodate you by offering you a light duty job at the same rate that you were making before you got hurt, that will also stop your weekly benefits, although again, your medical benefits will remain. But besides that, there are additional ways you can lose your benefits, and there is a way to keep that from happening. Usually, these things are usually accomplished through the schemes of the nurse case manager or the voc rehab counselor, or sometimes just because you made a misstep. And again, I refer to my book, especially the later chapters where I get into this. Okay, how do you prevent these missteps? Again, although there are no guarantees, the best way is to have a good lawyer with a team of folks who know the system to advise you how to behave and what activities to engage in, what activities not to engage in, to make sure that you don't get kicked out of benefits. Because the fact of the matter is that just by being a little absent-minded, or just by being a little hard-nosed and saying, "No, that's stupid, I'm not going to do that," you could lose your benefits in 1 second. And it can be almost impossible, not impossible, but almost impossible to ever get those benefits back. And even if you do, it can take a long time. So remember, this is despite the fact that you were under an open award order. Now, again, to learn about that some more, I'd refer you to the book, the 10 Traps and Lies book, included with this package, especially the later chapters. Also, I'd ask you to please be looking for upcoming emails and content that will be providing you for free, which provide some more specifics and advice about how to stay out of trouble if you're under an open award. So I want to thank you very much for taking the time to listen to this CD. I hope you've learned a lot, and then now you've got some idea what you need to do to ensure your rights are protected and what you're looking at in the as you go forward with your claim. Excuse me. In the meantime, if you've been severely injured on the job and you have questions about your case, please call us. Don't wait. If we decide to accept your case, as I mentioned before, you become part of our family. As you may have read about in the book, we practice something at the Work Injury Center that we call strong justice. It means that we focus on helping those people who we feel we're in the best position to help. We don't take every case that walks through the door. That's the way that we believe is the best way to serve our clients. Keep it limited and serve only those people that we can help the most. So if I'm your lawyer, you need to know that anytime there's a need for you to speak with me, and this is part of this strong thing that we call strong justice, my staff will schedule a telephone conference as between you and myself, and I have special time carved out to speak to my family of clients each and every week for that purpose. So, listen, I know this is a big decision for you. Please think about it. Pray on it. Remember this. If you're coming up on a time frame when you may be released by your doctor to light duty and you're not under an award order, your benefits are in grave danger. Do not wait. Call us right now. In the meantime, if there's anything we can do for you here at the Work Injury Center, if you have any additional questions about your claim, I invite you to contact us at 1-888-310-7798. Again, that number is 1-888-310-7798, toll free. One of my assistants will be happy to set up a time for you and I to speak about your case. One thing that would really assist us if you decide to do that and help us best help you is you notice that in the package there's some forms that you can fill out to give us your information, more detailed information about your claim. I think it would be great if you would go ahead and fill that out. You can fax it to us at the number indicated, which is 757-455-6757. Again, that number is 757-455-6757. That's our fax number. I'd also invite you anytime to explore the wealth of information and videos and other things that you can find online at www.joemillerinjurylaw.com. I thank you so much for listening. God bless you and your family. Be well.